Felony drug charges are serious because a person who's convicted of a felony drug charge can face very significant prison time. A person who possesses a small quantity of drugs for personal use is typically only charged with a misdemeanor, but a person will typically face felony drug charges because either he sold drugs or he possessed such a large quantity of drugs that the implication is that he possessed the drugs with the intent to sell them. Many defenses may exist in these cases that can result in you beating your felony drug charge. I'm going to go over some of the common issues in felony drug cases that can result in you beating your case. I'd like to emphasize that I'm a New York City criminal lawyer, so although many of the defenses that I'm going to discuss may exist in other states, I am speaking from the perspective of a New York City criminal lawyer who's seen hundreds and hundreds of drug cases play out in New York City criminal court. With any drug case, there's a question of how the police obtained the drugs from the defendant. Were the defendant's constitutional rights against unlawful search and seizure violated when the police obtained the drugs? If the police obtained the drugs through an unlawful search or seizure, then the drugs will be suppressed as evidence. And what that means is that the prosecution can't use that evidence at trial against the defendant. So when key evidence is suppressed, typically the prosecution will dismiss the case. And if they don't dismiss the case, they're very likely going to lose their case at trial because they won't have sufficient evidence to obtain a guilty verdict. Now, when a defendant engages in a drug sale with an undercover officer, most times he gives up his reasonable expectation of privacy in the drugs because he's giving the drugs away to someone else. So he doesn't have an expectation of privacy in those drugs. And so because of that, the drugs would very rarely be suppressed. So because of that, drugs that are involved in drug transactions are typically not suppressible evidence. However, when a defendant is charged with a felony drug charge for possessing drugs that the police obtained from the defendant's pockets, bag, vehicle, or home, then the police will need to have had legal justification to intrude inside of those areas where the defendant had a reasonable expectation of privacy. If the police didn't have legal justification to seize or search the defendant, then the evidence will be suppressed. Broadly speaking, the police will need a search warrant to enter and search a person's home. Also in New York, the police will also need a warrant to search inside of a person's closed bag, like a briefcase or a backpack. To search a person's vehicle, the police will need probable cause that there's evidence of a crime in all of the areas that they're searching inside of the vehicle. There are some minor exceptions to that rule that an experienced attorney can discuss with you if your case involves a vehicle. In terms of a person's pockets, the police will need reasonable suspicion that a person has a weapon in their pockets in order to frisk a person down to search for weapons. Or the police can fully search a person, pat them down, search inside of their pockets when they have probable cause to believe that the person committed a crime and they've arrested that person. And again, to be clear, there are exceptions to all these rules that an experienced criminal lawyer can go over with you after assessing the specifics of your case. Generally speaking, though, if the police seize or search you without the proper legal justification, the drugs they obtain can and should be suppressed as evidence, which will often result in the charges being dropped. Another common issue with felony drug cases is whether the defendant actually possessed the drugs. This defense usually comes up when the prosecution has charged a defendant under the theory of constructive possession. With constructive possession, the drugs aren't actually found in your pockets or on you, but the prosecution believes that you had dominion and control over the area where the drugs were found. So consequently, they were constructively possessed by you. A clear example of constructive possession would be if the police execute a search warrant at your home. Let's say that you live with your parents, but you have your own room. And the police search the whole home and they find drugs, but all of those drugs are contained solely in your room, inside your dresser. Let's say you weren't home at the time of the search, but the prosecution says that you constructively possess those drugs since you alone exercise dominion and control of the dresser inside of your room. So that's a pretty clear-cut example, and you wouldn't have a very strong argument that the drugs weren't yours. However, if the facts were slightly different, you might have a much better case. So, using the same example, and we change some of the facts around, let's say that instead of it being solely your room, you share the room with your brother. Or let's say that the drugs were found inside of a bathroom shared by multiple people in the home. Any of those factors, or a combination of factors, could certainly affect whether you had dominion and control over the drugs, and consequently whether you constructively possessed them. Another issue with some felony drug charges is whether the weight of the drugs is accurate. Some drug crimes require that the weight be solely the actual controlled substance, whereas some other charges allow the total mixture to be considered when determining the weight. So for instance, if you have an ounce of heroin, but it's significantly cut by other agents, you will be charged for the total weight of the mixture, not just the pure heroin. However, with some other drugs, the court can only consider the weight of the actual substance. Whether the weight has been properly established is dependent on the drug and the specific statute that you are facing. If you are facing felony drug charges for selling drugs, you may have a successful defense if you are merely acting as an agent for the buyer. In other words, you weren't making money from the transaction, you were merely helping an acquaintance score some drugs. If you weren't the actual dealer of the drugs and you were just merely helping out, then you may have a legitimate agency defense. If you've been charged with a drug felony in New York, give me a call for a free consultation. I can examine your case to develop a tailored defense strategy.